Good morning, Council. Before we get started, I just want to, remind you that actually we're supposed to be riding the circuit. We would be in another jurisdiction today. This case would be heard before an audience of mid-school children and high school children who have already read the briefs. This is an educational program that we participate in because of the Illinois Supreme Court Historic Preservation Commission, which sponsors this every term. Just like in the old days, the court would ride the circuit. So we thank you for participating. The video of this argument will be shown and the students will be able to see it at their school with their teachers. So thank you. The next case on the call of the docket is agenda number 126511. Is the agenda number 24, Marquita McDonald versus Symphony Bronzeville Park, LLC. Mr. McDonald.
Ms. Chief Justice, Counsel, may it please the Court. The Court of Appeals should be reversed in this case because it erroneously concluded that the plaintiff's workplace injury is not compensable under the Workers' Comp Act, even though that injury satisfied every single standard set forth in the Workers' Comp Act and this Court's decisions construing it. Plaintiff's workplace injury falls squarely in the plain text of the exclusivity provisions of the Workers' Comp Act, and the Court of Appeals failed to apply that plain language. Her injury occurred in the line of duty, it arose out of her employment, and it occurred during the course of her employment. Under the plain text of the exclusivity provisions, that is a compensable injury. It is the plain text of the statute that drives the compensability analysis. It is not how the plaintiff characterizes her injury in a pleading. There is no legislative exception for plaintiff's non-physical workplace injury. There's no judicial exception for her non-physical workplace injury. And when it comes to the compensability analysis under the Workers' Comp Act, the law does not distinguish between physical injuries, nor does it distinguish between non-physical injuries. In this case, plaintiff's injury was caused by a piece of equipment provided by her employer that she used every day as part of her normal duties and responsibilities. There is absolutely no support in the text and no support in this Court's rulings in Pathfinder, Collier, and Mirabray to distinguish her non-physical injury from the other non-physical injuries that this Court deemed compensable. And this Court has bent over backwards to send messages to judges and litigants alike of the breadth and scope of the exclusivity provisions. It has called them, they leave no room for construction, broadly worded, designed to cover the whole ground of liabilities. Yet, the Court of Appeals ignored them. What the Court of Appeals did was it focused on the character of the plaintiff's injury. And I could direct the Court's attention to paragraph 22 of the Court of Appeals decision. And if you'll indulge me, I will quote a portion of that. Quote, "We are not aware of a single Illinois appellate decision applying or expanding upon FOLTA's relatively new characterization of compensability." That is a fundamental misunderstanding of FOLTA. FOLTA did not create a characterization rule. FOLTA did not tell litigants and judges, you need to analyze this through the exclusivity provisions, but add a dose of the character of the injury. The word character or characterization appears nowhere in FOLTA. Now, where did the Court of Appeals get this? This is a trend in the lower courts that had been bubbling up, and in fact, that's exactly what they cite to as to how they arrived at this notion that a type of injury must consider the character of the injury. Further quoting that paragraph, it says, "We do agree with the following observation from a federal court considering the issue. The Folta court made clear that this inquiry is broader than just whether an injury arises out of and in the course of employment, and does, to some extent, consider the character of the injury." That is flat out wrong. The exclusivity provisions are clear on their face. They are faithful to facts. They do not succumb to characterizations and clever descriptions.
Didn't Pathfinder discuss the character of the injury when it defined the injury as a harmful change to the human organism?
Different courts, and let me be clear, I'm not disputing that you cannot characterize an injury, and courts can't characterize an injury. And in fact, in this case, the plaintiff characterized her injury initially as mental anguish, and then when she faced a motion to dismiss, she dropped that. She dropped the mental anguish, she dropped bodily injury, she dropped negligence, and she switched gears. And then she pled privacy injury. The problem with these characterizations arises when you analyze them in conjunction with the exclusivity provisions. There's nothing in and of itself wrong with coming up with characterizations of injuries, but look how many different ways this injury was characterized already. There's an endless number of ways lawyers can get creative and characterize the same injury, but that does not alter the analysis in the exclusivity provisions.
Why would the act specifically apply to employees only to have it preempted by workers' comp?
I'm sorry, could you repeat that, Your Honor?
Why would the act, the Privacy Act, apply to employees specifically only to have it preempted by workers' comp?
Well, Your Honor, remember, we're not saying all of her claims under the Biometric Privacy Act are preempted. It's only some of her claims. She is suing her employer for statutory damages and injunctive relief. It's only the statutory damages component against the employer that is preempted. She has a remedy against the employer for injunctive relief in court. She also has a remedy in court against any third-party biometric time clock vendor that falls under the guise of the Biometric Act. So our position is not restricting her rights. We are saying her remedy for statutory damages against the employer does not belong in court. It belongs at the Workers' Comp Commission.
Counsel, but doesn't that defeat the purpose of BIPA to prevent future violations of the Act? If the only relief that is going to be allowed is to give this particular party an injunction, does that not defeat the purpose of the Act?
Absolutely not, Your Honor, because remember, the most important aspect of BIPA is to stop the injury, and the injunctive relief component of BIPA, which is not preempted, she is within her rights to pursue that cause of action. And again, this is only in the employer-employee context. As I was just saying to Justice Burke, there are plenty of lawsuits, and she may have a cause of action against the vendor of the clock who is not her employer. But as to her employer, her claim for statutory damages belongs at the commission. And I want to drive another point home that I think is important. The so-called type of injury, and I think this is where the Court of Appeals misreads Folta. The so-called type of injury does not drive the analysis. And let me explain. Folta really stands for three things as we read it. I realize I'm talking to the author of the decision. It stands for three things, and the appellate court only focused on the first. And that first is whether an injury is compensable is related to whether the type of injury categorically fits within the purview of the Workers' Comp Act. The Court of Appeals focused on three words in that quote: type of injury. What they didn't do was consider the entire quote and the other two things Folta stands for. The way we read Folta, The type of injury that categorically fits within the purview of the Act is an injury that satisfies all the elements of the exclusivity provisions. But what Folta did is they focused on type of injury, and then they married the word characterization to that, and then they just ignored the plain text of the exclusivity provisions and concluded that this is not the type of injury that belongs within the purview of the Act. But what they failed to understand is there are two other aspects of Folta as the way it's applied. Compensability exists if the elements of the exclusivity provisions are satisfied, unless there is a categorical class without a right to seek benefits against the employer. And then here's the third most important thing Folta said. There is no categorical class without a right to seek benefits from the employer. That was true when Folta was decided in 2015. It is equally true today in 2021. The legislature has not created a categorical class of workplace injuries that are excluded from the Workers' Comp Act, and neither has this court. And I think it is absolutely critical that this court appreciate the extraordinary relief the plaintiff is asking for. She is asking this court to act as a quasi-legislature, to create out of whole cloth a new judicial exception to the plain language of the exclusivity provisions. She is asking this court to act as a blunt instrument to make a decision out of an act of sheer will. Her arguments are rooted in social policy and issues of fairness. But what she's asking is for this court to declare what the law should be as she sees it. That is not what we're asking for. We are asking this court to tell us what the law is. Whether the exclusion of workplace biometric injuries from the Workers' Comp Act is a good idea or a bad idea should be of no concern to this court. In fact, one of the real questions here is not whether workplace biometric injuries should be excluded from the Act. The real question is, who gets to decide that? Is it the courts or is it the people of Illinois? And make no mistake about it, there are billions, without exaggeration, billions of dollars at stake for Illinois employers facing these class action lawsuits. And the plaintiff is asking that 7 individuals outside of the ballot box decide the financial fate of those employers and, in turn, the employment status of those employees. This is a monumental decision. We are asking this court to do something very simple. We are asking the court to make a legal judgment based upon the text of the statute and this court's precedent interpreting that statute. The court should reverse. I welcome the court's questions.
Any questions? Okay. Thank you, Mr. McDonald. Mr. John Lawson?
Your Honors, Counsel, my name is Aaron Lawson. I represent the plaintiff appellee in this matter, Marquita McDonald. I do not believe that the Court of Appeals misread this court's decision in Folta. I think that the focus on the type of injury is exactly correct because this court has always understood the exclusive remedy provision, Section 5A of the Workers' Comp Act, in light of the text of the Act as a whole, and in particular in light of the compensation bargain struck in the Act. And if you'll permit me, the compensation bargain is this. It's that we have a set of injuries, and this court has said that the purpose of the Workers' Compensation Act is to provide financial protection for workers who are injured on the job until they can return to work. So we're talking about injuries that are rooted in physical harm that interfere with the employee's ability to do their job or to earn a living. Even in this court's decision in Pathfinder, when it held that mental injuries were compensable, it did so because it recognized that psychological harms do cause a harmful change in the human organism. So it's this set of injuries that is the subject of the compensation bargain. And employees are asked to surrender their litigation rights in exchange for no-fault compensation, and the employer is asked to surrender certain liability defenses in exchange for a cap on their liability. And this court has always understood the exclusive remedy provision as the mechanism by which we hold workers to their half of the bargain. And I think that's exactly what this court recognized in Folta, that if you have an injury that's not part of the bargain, that is, that's not categorically within the purview of the Workers' Compensation Act, then the exclusive remedy provision is not going to prevent a civil lawsuit from proceeding in the circuit court.
Is a person who is actually injured by a violation of this act in a worse position than someone who is not injured and suffers what this court's called a real and significant injury, but no problem with the human organism, I guess?
I would disagree. I think that
I'm not making an argument. I'm just asking whether a person is or is not in a...
Oh, as a general matter,
is a person,
someone who
it's
has
a question,
suffered
is a
some sort of
person,
actual harm.
right?
Yes, out in the world, yes. I think that person is potentially worse off. But I don't think that either category of plaintiff would need to proceed through workers' comp, because we have here the injury is the loss of a privacy right. That's what would entitle the person.
Well, wait, if the emotional distress injury had remained in the complaint, you're saying that's outside of the act also?
Yes, because you're entitled to that relief because you've lost your privacy rights. That is the underlying injury, right? Workers in Illinois enjoy a whole host of rights and protections that provide relief beyond merely the relief that is provided in the Workers' Comp Act for a violation of your right to be free from workplace accidents or bodily harm in the workplace. And I think to read the Workers' Comp Act, the exclusivity provision as foreclosing liability for all of that really throws the compensation bargain out of balance. And I think that even if you have here an injury that causes a type of harm that could be compensable in another circumstance, because the underlying injury is the loss of the privacy rights. That's what you get compensation for. That's what Ms. McDonald seeks relief for here. That's the only relief she's ever sought under BIPA.
So your argument is that all BIPA claims are excluded from workers' comp, even though the legislature has not excluded them from workers' comp? That's
correct. But I don't think the legislature would have needed to, because we're talking about a type of injury that's not part of the bargain in the first place. Right? When we look at what is within the bargain, as I mentioned, it's these physical injuries that interfere with the ability to do the job. And the loss of a privacy right is a different ball of wax entirely. There's nothing inherent in the loss of a privacy right that works a harmful change in the human organism. There's nothing inherent in the loss of a privacy right that would interfere with your ability to do the job. And I think it is. Go ahead.
What about the emotional stress that is a result of her loss of privacy? I mean, don't we have behavioral health requirements now regarding insurance? That people who have physical disabilities as well as behavioral health disabilities have parity with regard to compensation or help in that situation. So why wouldn't a privacy injury result in emotional distress? She's unable to do her job and be treated the same as somebody with a physical injury, loss of the use of a thumb.
I think the answer is that Folta tells us, and I think correctly, because we're looking at the exclusive remedy provision in light of the bargain, that we want to focus on the injury as a category. We're looking at, and I think this is actually the clearest takeaway from Folta, that we're not concerned with the specific circumstances of the plaintiff. If you have a type of injury that is theoretically compensable in all circumstances, like an injury to the person, then you might well be within the bargain. But if you have a type of injury, and I think that privacy injuries are a great example, that would not be compensable in all circumstances, or would not, to be more specific, would not be entitled to benefits through workers' comp in all circumstances.
But wasn't it the alleged fault of the employer?
It is, yeah. But But we have I mean, if you look at the common law, for instance, 3 of the 4 recognized common law privacy torts require proof of pecuniary harm or reputational injury, 2 categories of relief that you wouldn't be entitled to in workers' comp. The legislature has stepped in on occasion and said, we think these privacy rights are serious enough that the loss of them on its own should entitle you to compensation. That's also compensation that's not available in workers' comp. So when you look at privacy injuries as a category, right, the mental anguish is a really small slice of the available relief. So I think it's a mistake to suggest that privacy injuries as a category, as a type, are within the compensation bargain. And I think it's also notable, right, with respect to this statute, you don't have to prove things like emotional harms or interference with the ability to do the job. I think as the appellate court correctly recognized, the purpose of the Biometric Information Privacy Act is wholly distinct from the Workers' Compensation Act. We have a law here that's meant to redress a particular intangible injury, forestall future harm, and that's just a different, it's a different category entirely from this notion of providing financial protection to workers. And we could add, as the Workers' Comp Lawyers Association do in their brief, that the types of questions presented by privacy claims generally, by BIPA claims specifically, are really outside the remit and expertise of the Workers' Compensation Commission. And I think it is notable that it is not possible to get benefits for the loss of a privacy right through a workers' compensation claim. This isn't a situation like FOLTA, where you had an injury that is theoretically compensable, but given the specific circumstances of the case, the plaintiff would not have been entitled to benefits. You have an injury here that is in no way, shape, or form going to entitle the claimant to benefits, because it's not possible. There's no hook in the Act that would allow the Commission to provide benefits for the loss of a privacy right. And then I think the last thing that I would say, actually, before I move to that, I want to address quickly this notion that the second half of the compensability analysis relates to whether there's been a categorical class of workers excluded that appears, I think, for the first time in the reply brief in this court. I think it just suffices to say simply that that was language this court used to explain why its decision didn't deny Mr. Folta equal protection of the laws. It wasn't language intended as a gloss on the exclusive remedy provision or on compensability. And it's sort of a category error to transpose it anyway, because the equal protection analysis focuses on classes of workers. And when we look at the exclusive remedy provision in its application, we want to know about the injury. What type of injury is it? Where were you when you suffered it? What were you doing? You know, these are injury-focused questions, so it's really, it's sort of incoherent to read the equal protection analysis and transpose it back on to the workers' compensation analysis.
Is sexual harassment an injury?
I would, yes. And I think that's a good example of the type of protection that we have in Illinois for workers.
What's the physical injury in sexual harassment?
Well, I think harassment can be physical. It is, but it is frequently, and this, I think, goes to
Emotional distress?
right, exactly. So you have, and this is why I think it is a mistake to suggest that the mere ability to get damages for emotional distress is dispositive of the question of whether the type of injury should go through workers' comp. I think anyone who's been the subject of discrimination or harassment could plausibly allege that they've suffered mental anguish. But none of this court's decisions, and I think until this case, no one would have thought that claims for that sort of injury were compensable. And I think I mean, this court has said we can look at the consequences of a particular construction to see whether it's right. And I think that is a very clear indication that the way that Symphony reads the exclusive remedy provision as this blanket immunity from suit is wrongheaded. The last thing I want to say, I want to address, if this court does find some conflict between the Workers' Compensation Act and the Biometric Information Privacy Act, I think that the BIPA has to prevail. This court recognized in Rosenbach that substantial potential liability is part of the point of BIPA. The legislature found, it's in Section 5, this information is very sensitive. If it's compromised, if it falls into the wrong hands, serious, irreparable consequences can occur. So the rights that are granted through this statute are very important. And the legislature understood we want to incentivize compliance with this law. And the way we're going to do it is we're going to forego public enforcement. There's no provision for public enforcement. It's all down to private enforcement, and we're going to value these rights at a level sufficient to incentivize compliance. And that's what this court picked up on in Rosenbach when it said that substantial potential liability is part of the point. And I think it's inconceivable that a legislature would create this remedial scheme in a law that it says explicitly applies in the workplace. It acknowledged very explicitly its application in the workplace, knowing and intending that this somewhat unique remedial scheme would be inoperable with respect to anyone in Illinois who is an employee. I think that's...
You seem to suggest that the distinct categorical distinction should be on whether it affects the human organism. Can you explain that a little more to me?
I think that really the heartland of injuries that go to workers' comp are these injuries that are about which medicine has something to say, essentially, right? Some of the older appellate cases discuss compensability as a requirement of medical causation or as requiring the plaintiff to show demonstrable medical evidence of injury. And if you look at the types of benefits you can get under the law, right, it's injury to particular body parts, hospital stays, vocational rehabilitation, lost wages, and then temporary or permanent disability. We're talking about physical injuries connected to workplace accidents or conditions that really interfere with the worker's ability to do their job. And I think that is what the quid pro quo is about. So those are the injuries for which the workers surrender their ability to proceed in court. And I think expanding it to intangible injuries runs the risk of sweeping a whole host of kind of unrelated grievances that can't be redressed through workers' comp, for instance, discrimination, into this workers' compensation system. And rendering...
I don't understand why an emotional distress which requires mental health, help, and also perhaps a person cannot return to work because of the severity of it. That doesn't get compensated?
I think when we're looking at this from the
Only physical injury, like Justice Garment said, to the human body,
well,
but not mental.
I would agree that disabling physical or disabling psychological injuries, can be compensated if you've got this underlying connection to the workplace accident or the workplace condition, that this right to be free from an unsafe workplace.
So how do we draw the line? What do we say?
Well, I think you could follow the appellate court's lead and say we look at statutes that address intangible injuries, that address problems distinct from what workers' compensation is doing, that the legislature has identified a type of injury that is not compensable. I think you could, on the other hand, say that the provisions of the Workers' Compensation Act show the type of injuries that this law applies to, that this compensation bargain relates to. And if you have an injury outside of that, as we do here, because for all the reasons I've stated, that you've got no provision to compensate for the loss of a privacy right, and it's just distinct in character, that also is non-compensable. I think either of those are doctrinally sound ways to reach the result we advocate for here, which is to affirm the judgment of the appellate court. If there are there any further questions?
Questions? All right, thank you, Mr.
And I will sit down. Thank you.
Mr. McArdle?
Thank you. I want to make 3 points. Counsel continues to go back to this notion that the type of injury drives the compensability analysis. Allow me to give a very simple example to demonstrate why that's not true. If I go to work and I'm walking through the plant and I trip and fall and suffer a black eye, that's going to be a compensable injury. On the other hand, if I suffer a black eye at work because my supervisor committed an intentional tort and slugged me in the eye, that is not going to be a compensable injury. They are the exact same injury. That's why it doesn't drive the analysis. The exclusivity provisions do. The second thing, counsel, we saw this in their brief, and I need to address it. We are not asking for this so-called blanket immunity from liability to be shielded from things like the Illinois Human Rights Act when discrimination and harassment claims are filed, or the One-Day Rest in 7 Act, or the Illinois Minimum Wage Law. All of those statutes don't involve accidental workplace injuries in the line of duty. So that is a red herring. It's a hyperbolic scare tactic that we've never made that argument, and that's not what we're asking for.
Just so I'm clear, Just so I'm clear, we've raised the issue of sexual harassment. Is a claim of sexual harassment in the workplace appropriate to bring exclusively in at workers' compensation, or can that claim be brought in the circuit court?
A claim of sexual harassment is not preempted by the Workers' Comp Act. It involves intentional acts. And that, when we look at the analysis of the exclusivity provisions, one of the components is, was it accidental? And sexual harassment, by its nature, is an intentional act.
And therefore, it may be brought into the circuit court?
Yes.
Okay. And so is the intentionality, is that the most important factor we should be looking at?
I don't know that it's the most important. The most important factors is following the roadmap that the exclusivity provisions provide us. The beauty of those provisions is it tells judges and litigants early on whether or not this is an injury that's preempted by the Workers' Comp Act or not. It's a clean, neat, simple test that is faithful to the facts and exceedingly practical. Interjecting these notions of descriptions and labels and characterizations into that analysis is going to lead to arbitrary decisions. And employers and employees and judges alike, they need consistency and predictability in the law. Otherwise, if we interject this compensability rule, that will more than water down the language of the text and the exclusivity provisions. It might just eradicate it altogether. And you'll have judges sitting in courtrooms side by side with the same type of injury, reaching different results. Why? Because one characterized it one way and one characterized it the other way.
Counsel, it seems as Mr. Lawson is saying that you have to have something tangible, an injury, physical to the body, and that everything else that, well, anything that might be behavioral, psychological isn't included in the compensation. And is that a good analysis? I mean, is that what we're thinking, or?
No, we disagree with that. And if you look at this court's decisions in Pathfinder, Collier, and Mirabray, those cases did not involve physical injuries. They involved emotional distress, Mirabray especially, false imprisonment. He pled anguish just like the plaintiff did here the first time. He pled fear, hunger, thirst. In Collier, it was emotional distress. In Pathfinder, it was a psychological disability. And this court in Pathfinder reminded all of us that there was little support to distinguish between a psychological injury that is precipitated by a minor physical injury versus a psychological injury that is not precipitated by a physical injury. And the same applies here. There is no principal distinction between the non-physical injuries that this court has found compensable and this plaintiff's non-physical injuries.
May I go back to the intentionality piece? Is a violation by the employer of the Biometric Information Privacy Act an intentional act?
We don't believe so, Your Honor. Our client and every employer I know who used the biometric technology time clocks in this case, they intended to comply with the federal and state wage hour laws by putting in a piece of equipment that accurately captures when employees clock in and clock out. They did not install these They did not intentionally install these machines because their real motive was to capture somebody's biometric information. They
Is
wanted
that the analysis, though? I mean, there's a statute out there, a pretty complicated statute, that certainly employers should be aware of, that limits dramatically the capture of biometric information without consent. So if the employer disregards that statute, isn't that an intentional act?
I don't think so, Your Honor. I don't think any employer intentionally violated the Biometric Privacy Act. Frankly, I think most didn't even know about it. It was not placed in the employment section of the code and, quite frankly, caught Illinois employers off guard. But no, I think the intent is to capture time accurately so we can pay employees in accordance with federal and state wage hour laws.
What do you claim to be the types of injuries in the Biometric Act? What are the kinds of injuries that are suffered, from your view, in a violation of that act?
From our view, there's no physical injury, and the number of potential non-physical injuries, they're potentially limitless. I think it's going to come down to every individual. One individual may say, I've suffered emotional distress. One individual may say what the plaintiff said initially, bodily injury in the form of mental anguish. We've seen other plaintiffs allege, I have fear and anxiety over what might happen. As I said, there are multiple ways to describe these non-physical injuries. But
Now, this fear and anxiety about what happened, is that covered by the Workmen's Compensation Act?
according to Mirbrae, it is. That is almost very similar, if not exactly, some of the ways in which the plaintiff there, he was subject to false imprisonment with his captors, if you will, denied food, denied water. He pled fear, humiliation, and anguish.
From false imprisonment?
From false imprisonment.
But are the intentional acts we speak of putting the clock in and then requiring the use of the clock, or intending to violate a statute? That's more of a knowing issue than an intentional issue. The intentional act was committed. The employer put it in and told him to use it.
Right, but that's really going to the accidental component of the Workers' Comp Act. Now, I don't think that's before the court, but nevertheless, yes, employers intentionally put in these machines, but I don't think anyone could argue convincingly that the intent was to violate the law or the intent was to steal biometric information.
So they intentionally put the machines in?
Sure.
But then you say any violation was accidental?
No.
Because they intentionally put them in, but I guess you're saying that they weren't aware of all the ramifications?
Exactly.
Of putting it, that's what you're saying?
Yes, the
And that's what you
accident.
claim to be accidental?
Right, the accident was, gosh darn, we didn't know that we had to comply with this act, and yes, they accidentally violated the act.
By intentionally putting the machines in?
They did intentionally put the machines in. They certainly didn't appear on their own. But the intent, as I said, was to comply with wage hour laws, not to violate the biometric law.
Is it a result, though, that workers' compensation doesn't want to include behavioral health?
Your Honor, far be it for me to speculate what workers' comp the system does and does not want to do. I believe it does account for non-physical, mental, and psychological disabilities.
Counsel, you're saying their ignorance, the employer's ignorance of the law is the excuse for not complying with HIPAA?
In our case, it is they were unaware of the hoops they needed to jump through to comply with HIPAA. But their intent was not to violate BIPA. But once again, it was to comply with wage hour laws.
Thank you, Mr. McDonald.
Thank you.
Case number 126511, Marquita McDonald individually versus Symphony Bronzeville Park LLC will be taken under advisement as agenda number 24. Thank you, Mr. McArdle, and thank you, Mr. Lawson, for your arguments this morning.